Well, the Supreme Court has shut down affirmative action at colleges, banning schools from considering race during the admissions process. The ruling stated that Harvard University and UNC's policies go against the Constitution. Yahoo Finance's Alexis Keenan joins us now with the details. Hey, Alexis.
Hi, Rochelle. This is just such a huge ruling, and it's such a sweeping change for how colleges do go through the admissions process in the United States. Now, the question in this case was, can public universities, private universities consider race when they're looking at applicants in college admissions? And the answer in a 6-3 ruling down ideological lines was no. The majority writing that Harvard and UNC's admissions programs violate the Equal Protection Clause of the 14th Amendment that says no state shall deny any person within its jurisdiction equal protection of the laws. Now, those laws across states, they generally bar governments from race-based discrimination. So that's kind of how the pieces fit together in this case. Now, dissenting in both cases, Sotomayor, Justice Kagan, Justice Jackson, all dissenting. Also, Justice Jackson having had recused herself from the Harvard case because she is an alumna of the school. Now, this impacts arguably all college applicants in some way, whether they're a minority or not. Today, approximately 40% of U.S. universities do use race in their admissions process. Now, in both of these cases, the plaintiffs were the same. They are the Students for Fair Admissions. And they argued that the plaintiffs, they were saying that race should not be used any longer because they said that Asian American applicants were being discriminated against to their detriment, and that it was finding that it was less likely that they would be admitted to college universities than similarly situated and qualified white, Black, and Hispanic students, as well as Asian students there. So this case, though, it overturns just a long line of cases in the United States, going all the way back to Brown versus Board of Education, which overturned separate classroom atmospheres for students based on race. But more particularly, there's a 2003 case called Grutter v. Bollinger, and that okayed the use of race, and that was a University of Michigan case, the law school in that case. And they said that the justices at that time in 2003 ruled that it's okay so long as race is one narrow factor among a lot of factors that are included when considering college applicants. But really tellingly, back at that time, Justice Sandra Day O'Connor, a Reagan appointee, she was the swing vote in that case. She penned the majority in that case, and she predicted that after 25 years, affirmative action would no longer be necessary to make colleges more diverse, though certainly still a debatable issue still today, whether this was the timing for this or not. That is going to be, I'm sure, hotly contested here.
Indeed, because I know a lot of people have concerns, questions about what this means for the pipeline of talent who are able to access college and perhaps enter the workforce. So then, could this have any wider implications beyond the universities?
Yeah, and you hit on it right there, Rochelle. This is a case where amicus briefs, those are front of the court briefs, where they're submitted on one side or the other. These two cases, I keep calling it one case, but it's two cases, Harvard and the University of North Carolina. We had Apple, GM, Starbucks, and approximately 40 major U.S. corporations all siding with the idea that affirmative action is still a good practice and should be constitutional because of that pipeline. They say that they're able to hire out of a pool of more diverse candidates as college graduates if these practices stay in place. So definitely had so many corporate actors wanting this to turn out a different way today, though. Writing in the majority, the Chief Justice John Roberts wrote this when he said, eliminating racial discrimination means eliminating all of it. Rochelle?
I appreciate you giving us that update. Our very own Alexis Keenan there.